2023 presidency, storm over Jonathan's eligibility. Welcome to the news and please subscribe to our channel. Lagos human rights lawyer Mr. Femi Falana San and the Law and Order group yesterday disagreed over the eligibility of former President Goodluck Jonathan to contest for presidency in 2023. While Falana insisted that Jonathan cannot run by virtue of 137(3) of the 1999 Constitution, the Law and Order group disputed Falana's assertion. There have been speculations that the former president may defect from the People's Democratic Party (PDP) to the ruling All Progressives Congress (APC). Jonathan was elected president of Nigeria in the 2011 general election but lost to Muhammadu Buhari in 2015. But Falana in a statement said the former president has been disqualified by virtue of 137(3) of the 1999 Constitution. The statement reads, "It has been confirmed that former President Goodluck Jonathan has decided to join the APC for the purpose of contesting the 2023 presidential election. However, the former president is disqualified from contesting the election by virtue of 137(3) of the Constitution of the Federal Republic of Nigeria 1999 as amended, which provides as follows: that a person who was sworn in to complete the term for which another person was elected as president shall not be elected to such office for more than a single term." Some people have said that amendment is not retrospective and therefore cannot be applied to Dr. Jonathan. Assuming without considering that the amendment is not retrospective, it is submitted that under the current constitution, a president or governor cannot spend more than 2 terms of 8 years. In other words, the constitution will not allow anyone to be in office for more than a cumulative period of 8 years. In Mawa Vehicle 2012 6 NWLR PT 1296 199 at 387, the Supreme Court stated that Section 180 1 and 2A of the 1999 Constitution of the Federal Republic of Nigeria has prescribed a single term of 4 years, and if a second term, another period of 4 years and not a day longer. In the case of Governor Ladoja versus INEC 2008-40, WRN 1, the Supreme Court rejected the prayer of Governor Ladoja, the 11-month extension to cover the period he was kept out of office through illegal impeachment. The Supreme Court rejected the prayer on the ground that a governor is entitled to spend a maximum period of 8 years or less and not more than 8 years. It is not in dispute that Dr. Jonathan became the president of Nigeria in 2010 following the sudden death of President Umaru Yar'Adua. He later contested and won the 2011 presidential election. Having spent 5 years in office as president, Dr. Jonathan is disqualified from contesting the 2023 presidential election. The reason is that if he wins the election, he will spend an additional term of 4 years. It means that he will spend a cumulative period of 9 years as president of Nigeria in utter breach of Section 137 of the Constitution, which provides for a maximum of 2 terms of 8 years. Group counters Falana. But the Law and Order group yesterday disputed Falana's assertion that a former president is not qualified to contest in the 2023 general elections. The group, in a statement by its coordinator, Aliyu Mohammed, said, "We wish to categorically state that the said statement is erroneous and misconceived. In the first place, the fourth alteration of the Constitution, which introduced Section 1373, was signed into law as part of the Constitution of the Federal Republic of Nigeria 1999, as amended by President Muhammadu Buhari in June 7, 2018. The said Section 1373 contains a commencement date, which is the date it was signed into law. Thus, the provisions of Section 1373 of the 1999 Constitution, fourth alteration, became operative on June 7, 2018, and not any time before that date. The law is settled beyond controversy or dispute that a law does not take effect retroactively. Again, it is a law that where a piece of legislation set out a specific commencement date, as in the case of Section 1373, all rights, duties, obligation, and interest created or intended to be created or imposed by that law will not be applicable to rights, events, or duties which accrued or occurred before then. The case of Modo versus FRN 2015 LPELR 4047 is very apt. As we all know, Jonathan left office since 2015. The oath of office which he took were taken prior to the enactment of Section 1373. In a case decided by the Court of Appeal in 2015, the court rightly held that the oath of office sworn to by Jonathan on May 6, 2010 cannot be taken into account in the interpretation of Section 1371 of the Constitution. It follows, therefore, that the only oath of office sworn by Jonathan is the one he took on May 29, 2011. Again, it is not in dispute that Jonathan contested the presidential election in 2015 on the basis of the right which accrued to him. It follows, therefore, Jonathan has the right to contest the forthcoming presidential election on the platform of any of the registered political parties in Nigeria. I don't even know if Uncle Jonathan is going to take this or not. But let's just wait and see how things play out. On this note, we have come to the end of the news. We say thank you for tuning in to listen. Until I come your way next time, enjoy the rest of your day.